Jefferson County Court at Law number 2 is back in session. Next case is cause number 327066. The case is styled the State of Texas versus Stacy Elizabeth Tomplate. We have Ms. Tomplate, who's present with her attorney, Attorney Alderman Samuel. State is represented by Attorney Lamar Johnson. Mr. Johnson, this case, are you requesting a bench trial?
Yes, Your Honor.
You, Mr. Samuel, you have any objections?
No objection.
Mr. Samuel, are you ready to go forward?
Yes, Your Honor.
Mr. Johnson, are you ready to go forward?
Yes, Your Honor.
Okay. Mr. Johnson, would you please read the information in this case?
Yes, Your Honor. Cause number 327066, the State of Texas versus Stacy Yvette Tomplate. Misdemeanor charge for assault, Class A misdemeanor. The information reads in the name and by the authority of the State of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the State of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Stacy Yvette Tomplate, hereafter style, the defendant heretofore on or about April 16, 2020, did then and there intentionally, knowingly, and recklessly cause bodily injury to Monica Rankin, hereafter style, the complainant, by striking complainant about the face and body with her fist.
Against the peace and dignity of the state?
Against the peace and dignity of the state.
Okay. Now, Mr. Tomplate, to this charge, how do you plead? Not guilty or guilty or no contest?
Not guilty, sir.
Okay. All right. Now, Mr. Johnson, are you ready to go forward?
Yes, Your Honor.
Hold on a minute. Okay, Mr. Johnson, would you please call your first witness?
Yes, Your Honor. The state calls Monica Rankin.
Okay, would you please call Monica Rankin?
No response.
Okay, Mr. Johnson, do you have any other witnesses?
No further witness, Your Honor.
Okay, does the state rest?
Yes, Your Honor. State first.
Defense?
Defense has no witness, Your Honor.
Okay,
We rest.
okay, state, do you have a motion? Right, I'm just asking.
Defense moves for an instructed verdict of not guilty.
Okay, at this time, that motion will be granted. And Ms. Tomplate,
Yes, sir.
what that basically means is you've been found not guilty.
Thank you.
And your attorney is going to get a copy of your of the judgment of this the judgment in this case. Matter of fact, he has it right now. So you're free to go and you have a blessed day.
Okay, thank you very much. You
Okay.
too.
Okay, next case. We have next two cases is Eric Martin Sigris Jr. Which case are we going to proceed on first? Yes, two cases. are we proceeding on the assault or the interference first?
It doesn't matter.
Okay,
It doesn't matter. It's up to the court.
okay. Next case is cause number 328-430. Case is style the state of Texas versus Eric Martin Segrist. And Mr. Segrist, is that your full name? Is Eric Martin Segrist Jr., is that correct?
Yes, sir. Yes, sir.
Okay, Mr. Segrist, you're represented in this case by your attorney, Ryan Matuska, who's appearing via Zoom. Attorney Matuska?
Yes, sir, Your Honor.
Okay, Attorney State, are you requesting that we proceed with a bench trial in this case?
Yes, sir. State waives its right to a jury trial and would ask that we proceed with a bench.
And Mr. Matuska, are you waiving your client's right to a jury trial as well?
Yes, sir, Your Honor.
Okay, now, Mr. Matuska, are you ready to go forward?
I am, Your Honor.
And State, are you ready?
State's ready, Judge.
Mr. Coleman, would you please read the information?
Yes, Your Honor. In the name and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Eric Martin Segrist, after style of defendant, heretofore on or about November the 25th of 2020, did then and there knowingly prevent and interfere with the ability of Perla Munoz, hereafter style the complainant, to place an emergency telephone call and to request assistance in an emergency from a law enforcement agency, medical facility, and or agency or entity whose primary purpose is to provide for the safety of individuals against the peace and dignity of the state.
Mr. Segrist, how do you plead? Not guilty, guilty, or no contest?
Not guilty, Your Honor.
Not guilty? Okay. State, are you ready to call your first witness?
Yes, Your Honor. State calls Perla Munoz.
Well, before we do that, do you desire an opening statement?
No, Your Honor. State waives its open statement.
And Mr. Matuska, do you desire opening statement or do you waive your opening statement?
Waive, Judge.
Okay. Mr. Coleman, you may call your first witness.
Yes, Your Honor. State calls Perla Munoz.
Mr. Coleman, do you have any other witnesses?
No further witnesses, Your Honor, and the state unfortunately rests.
State rest.
Yeah.
Mr. Matuska,
No witnesses, Your Honor. We just make a motion for a directed verdict.
okay, the court is going to grant an instructed verdict in this case. And what that means, Mr. Eric Segrist, is that you've been found not guilty in this case in cause number 328-430. And we will give you a copy of that, of the judgment as soon as we finish here today. The next case is cause number 328-940. And the case has the same style, state of Texas versus Eric Martin Segrist. Mr. Segrist. And Mr. Matuska, are you requesting that you waiving your client's right to a jury trial in this case?
Yes, sir, we are.
And the state?
Yes, sir. The state likewise waives its right to a jury trial and has to proceed on with the bench.
Okay. Now, are you ready? And those that will be granted, both motions will be granted. Now, Mr. Coleman, are you ready to go forward?
Yes, Your Honor. State's ready to proceed.
And Mr. Matuska, are you ready to go forward?
Ready, Your Honor.
Okay, Mr. Coleman, would you please read the information in clause number 328-940?
Yes, Your Honor. In the name and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presenting into the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Eric Martin Segrist, hereafter styled as defendant, heretofore on or about November the 25th of 2020, did intentionally, knowingly, and recklessly caused bodily injury to another, namely Perla Munoz, hereinafter styled the complainant by beating complainant about the face and head with fists. And at the time of said assault, complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state of Texas.
Mr. Segrist, how do you plead? Not guilty, guilty, or no contest?
Not guilty, Your Honor.
Not guilty? Okay. Mr. Coleman, do you desire an opening statement or do you waive an opening statement?
State waives its right to an open statement, Judge.
And Mr. Matuska, do you desire an opening statement or do you waive the right to an opening statement?
We also waive, Your Honor.
Mr. Coleman, you may call your first witness.
State calls Perla Munoz.
There's no response. Mr. Coleman, would you call your next witness?
Regrettably, the state has no further witnesses, Judge, and the state would unfortunately have arrested.
Okay, Mr. Matuska?
No witnesses, Your Honor. We move for a directed verdict.
Okay, the court will grant instructed verdict in this case. Mr. Seegers, you have been found not guilty in this case. You're gonna get a copy of the judgments. You've been acquitted, so once you get your judgments, you're free to go and you have a blessed day. And Mr. Matuska, I think these are your only two cases that you have in court today, is that correct?
Yes, sir, Judge.
Okay, so you're free to go as well and you have a blessed day.
Good, thank you.
Yeah, but hold on, Mr. Matuska, they say you have another one.
Oh,
Who does he have? Oh, Guillory? John Guillory? You come forward. That's on the page 4 of the announcement docket. John Angel Guillory. This is cause number 331154. Case is styled the state of Texas versus John Angel Guillory. Mr. Guillory, is that your full name? Okay, how are you doing, Mr. Guillory? Okay. Mr. Guillory, you're represented in this case by your attorney, Attorney Ryan Matuska. And Mr. Matuska, what is your announcement in Mr. Guillory's case?
Your Honor, I see here that we're still reviewing discovery and gathering discovery. Could I get 30 days for an announcement?
Okay, we can reset your case to the next announcement docket okay, next available is December 5th, 2022. Mr. Guillory, your case is gonna be reset on the next available announcement docket. You're gonna stand on the floor, get your reset from our court coordinator. Once you get your reset, you'll be free to go. You have a blessed day, and thanks for being patient here today. And Mr. Matuska, this is the last case, so you're free to go as well. Your reset will be sent to you, and you have a blessed day.
Yes, sir. Thank you.
And at this time, the court will be in recess. Okay, this is cause number 321-394. Case is filed in State of Texas versus Chase Wade Ellis. We have Mr. Ellis, who is present in court. Mr. Ellis, is that your full name?
Yes, sir.
Okay, how are you doing, Mr. Ellis?
Pretty good. So,
I'm doing fine. Now, Mr. Ellis, you're represented by Attorney Keith Ellis. Is that correct? Now,
yes,
Mr.
sir.
Keith Ellis is not here, and you have some information as to why he's not here.
Yes, sir. This morning I went by his house where, he stayed up a little late last night preparing for the day. Thought we were going to trial and, this morning the ambulance had to come get him. His blood pressure was, I think, 240/150, if I'm not mistaken. So, it's pretty high. He's in the hospital right now.
I understand those things happen. I don't want to seem uncaring or cold-hearted. It's just that over the course of the past week, I have made several attempts to reach out to Mr. Ellis to see if we can come to some resolution. I have no doubt what's been the same.
Has you talked to him?
No. I have all of my attempts to reach out to Mr. Ellis have been unsuccessful.
Do you know whether or not you have a good number or phone number? I mean, you don't need to, you can give it to him. I mean, not
Yeah,
now.
yeah,
Hold
I
on,
don't
yeah,
think-
you don't, I mean, what I'm saying is we on YouTube right now. I mean, we can provide him with that, but what we need to do, this case is actually set, and this is the oldest case on this docket. And, we're not gonna have no, we're gonna have to keep track of Mr. Ellis's, condition, but we're not gonna, this case is not gonna be out there, forever. Okay?
Yes, sir.
So, I'm inclined to, what we got, I'm putting it on maybe on a 2-week reset. Is that fine, or 1 or 2 weeks?
That's fine with the state judge.
Unless let me do this here, before we do that, let's see if we can get something from, today.
I would prefer to have some type of documentation.
Okay.
Again, I'm not calling
Okay.
into question the defendant's truthfulness on this, Judge.
Okay,
This is a case that lends itself
okay.
to negotiation.
Okay, now let me do this here before we, I'm not gonna give you a reset right now. But what I need is from you or Mr. Ellis, documentation of his, medical, just some,
Or, Judge, the state would be satisfied with a filing, under the penalty of, under the rules of professional responsibility by the defendant that says that, this is why he's seeking a continuance. I mean, if he's putting something false in a pleading, there's consequences for that.
okay, so what we'll do, we're gonna keep this on, right now, we're not gonna remove it.
I'm not even sure if he's stable at this point.
Okay, well, we'll find out. Right now, the case is still gonna be on the docket,
Okay.
right? And so our docket, I'm gonna give you till, you need to give us something about 1:30 tomorrow. Because we got a docket, tomorrow that we starting our jury trial tomorrow at 1:30. Okay, like I said, this case is this is the oldest case. So this case has, is a high priority,
Yes, sir.
okay? All right, so we need, actually, we need to have you back here tomorrow at 1:30.
Okay, with documentation?
Yeah, him, Dr. Hill, I don't know, but at this point, we don't know what's going on. Okay, so we just need to have something so we'll know how to move forward,
Yes, sir.
right?
Okay.
Okay.
I would imagine I can get that. I'm headed there soon.
Okay, all right, so at this time, we'll see you, this case is reset till tomorrow at 1:30.
Yes, sir. Thank you.
Do you need to reset
Very
it?
good.
Give him, just give him a reset for 1:30 tomorrow. She's gonna give you a reset for 1:30 tomorrow. Okay, and, we hope that, everything is fine with Mr. Ellis. And tell him that we praying that he have a full and speedy recovery.
Thank you.
Okay. Court is in session in two cases. First case is cause number 328086. Second case is cause number 329266. Both cases are styled state of Texas versus Kashmir Annette Morgan or Kashmir Annette Monique Morgan or just Kashmir Morgan. Now, Ms. Morgan is present in court. Ms. Morgan, is that your full name, Kashmir Annette Monique Morgan?
Yes.
How you doing, Ms. Morgan? That's good, Ms. Morgan. You're here with your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge.
That's- Okay. Mr. Reynolds, how are you doing?
Doing well.
And the state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
Pretty well.
Okay. Now, Mr. Reynolds, are you questioning that this, you waiving your right, your client's right to a jury trial? So you waiving the right to a jury trial in this case?
At this point, we are.
And requesting a bench trial?
Yes, sir.
And the state, you what?
State's waiving his right to a jury trial, Your Honor.
Okay, so we having a bench trial. Now, Mr. Johnson, is the state ready to proceed?
Yes, Your Honor. State.
And Mr. Reynolds, is the defense ready to proceed?
We are ready.
Mr. Johnson, will you please read the information in cause number 328086?
Yes, Your Honor. The state of Texas versus Kashmir Annette Morgan. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County on behalf of the state of Texas and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Kashmir Annette Morgan, hereafter styled the defendant, heretofore on or about September 23rd, 2022, did then and there intentionally and knowingly enter the habitation of another, namely Treasure Hill, without the effective consent of Treasure Hill, and the said defendant had noticed that the entry was forbidden against the peace and dignity of the state.
Did you say September 23rd, 2022?
2020, Your Honor.
Oh, it's 2020, okay. And Ms. Morgan, to this charge, how do you plead? Not guilty, guilty, or no contest?
Not guilty.
Okay. Mr. Johnson, are you requesting an opening statement, or are you waiving right to an opening statement in this case?
The state's waiving his right to open statement.
And Mr. Reynolds, are you requesting an open statement, or are you waiving the right to an open statement in this
Waive
case?
it.
Mr. Johnson, you may go forward. You may
Yep.
call your first witness.
Your Honor, the state calls Treasure Hill.
Treasure Hill. Treasure Hill. Treasure Hill. No response. There's no response. Mr. Johnson, do you have another witness?
No, Your Honor. State rests, Your Honor.
Okay, Mr. Reynolds,
We would move that the court enter a finding of not guilty based on insufficient evidence and acquittal.
okay. At this time, the court is going to grant an instructive verdict in this case. And Ms. Morgan, what that basically means is you've been found not guilty. Your attorney is going to get a copy of this judgment. And the next case that we have is cause number 329266, case of style state of Texas versus Kashmir Morgan. Mr. Johnson, are you ready to proceed?
Yes, Your Honor. State.
And Mr. Reynolds, are you ready to proceed?
Defense is ready.
And state, will you please read the information in this case?
Yes, Your Honor. The state of Texas versus Kashmir Morgan. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court of Law of Jefferson County, Texas, that in Jefferson County, Texas, Kashmir Morgan, hereafter styled the defendant, heretofore on or about March 7, 2021, did then and there intentionally, knowingly, and recklessly cause bodily injury to Gerardo Ray, hereafter style the complaint by punching complaint to the head against the peace and dignity of the state.
Okay. And Ms. Morgan, to this charge, how do you plead? Not guilty, guilty, or no contest? Mr. Johnson, do you request an opening statement, or will you waive an opening statement in this case?
The state waived the opening statement. Your Honor.
And defense, will you be requesting an open statement, or do you waive an open statement?
Waive the opening statement.
Okay. Mr. Johnson, you may call your first witness.
Thank you, Your Honor. The state calls Gerardo Ray. Gerardo Ray. Gerardo Ray. Gerardo Ray.
Now, let me do this here. The, I see you said Geraldo Ray. Would it be also pronounced Geraldo Ray? Would you, because I think it's the way it's spelled. I think it may be pronounced Geraldo Ray. Yeah. Okay, there's no response. Mr. Johnson, do you have any other witnesses?
No, Your Honor, state arrest.
And Mr. Reynolds?
Move the court find Ms. Morgan not guilty for insufficient evidence and enter an acquittal.
Okay, at this time, the court is going to grant an instructed verdict in this case. Ms. Morgan, what that basically means, you've been found not guilty of these charges. Your attorney is going to get a copy of that judgment. Once you get a copy of the judgment in both of these cases from your attorney, you'll be free to go and you have a blessed day. Okay, okay, you're welcome. Would you please? It's the one, yeah, found not guilty, instructed verdict of court. Now, jury. Hold on a minute. This is cause number 326318. Case of style, the state of Texas versus Woodrow Wilson Ratcliffe III. We have Mr. Ratcliffe, who's present in court. Mr. Ratcliffe, how you doing? That's good. Mr. Ratcliffe, you're here with your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how are you doing again?
I'm doing well, Jay.
And the state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well now.
Now, Mr. Reynolds, are your client waiving his right to have a jury trial in this case?
No way.
And the state is also waiving its right?
Yes, Your Honor, state waives the right to a jury trial.
Okay, so at this time, state, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
We're ready.
Mr. Johnson, would you please read the information in cause number 326318?
Yes, Your Honor. The state of Texas versus Woodrow Wilson Ratcliffe III. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law, Jefferson County, Texas, that in Jefferson County, Texas, Woodrow Wilson Ratcliffe III, hereafter styled, the defendant heretofore on or about December the 11th, 2019, did then and there unlawfully, recklessly engaged in conduct that placed Caffrey Francis, hereafter styled, the complainant, in imminent danger of seriously bodily injury, namely by pointing a gun at complainant against the peace and dignity of the state.
Mr. Ratcliffe, how do you plead? Not guilty, guilty, or no contest? Not guilty. Mr. Johnson, do you request an opening statement in this case, or do you waive the right to an open statement?
State waives the right to open statement.
And defense, do you request an open statement, or do you waive the right?
Defense waive.
Okay, at this time, Mr. Johnson, you may call your first witness.
Your Honor, the state calls Caffrey Francis.
Francis.
No response.
There's no response. Mr. Johnson, do you have any other witnesses?
No, Your Honor, the state rests.
And Mr. Reynolds?
We move the court to find the defendant not guilty by reason of insufficient evidence and enter an acquittal.
Okay, that motion will grant, the court will grant an instructed verdict in this case. What that means, Mr. Ratcliffe, you've been found not guilty. Your attorney is gonna get a copy of your judgment. Once you get a copy of your judgment, you're free to go and you have a blessed day. Yeah.
The police seized a weapon. Do we need to put something in the order to get his weapon?
They don't have no reason to hold it at this point. I mean, the judgment, you got a judgment.
I didn't know if it needed to be put in the judgment with weapon being found.
I don't, think, I mean, by statute, I don't think so. I mean,
Okay. Good.
yeah. Yes, that's it.
Have a good day. Thank you.
Okay. You're welcome.